Friends, I welcome you all at Swayam platform. Now we are going to start our second lecture, which is titled as Coparcenary and Coparcener. Before starting anything, I want to summarize what we discussed in the last class. We discussed the general introduction of Hindu Succession Act in the last class, where we try to understand the law of succession and law of inheritance. We understand that succession is a wider term, inheritance is a relatively narrower terminology, which only includes intestate succession. Friends, we also understand the basic features of the act. On that, we discussed that this act includes the detailed rule about the intestate succession. We discussed that the provision of section 2622 enacted under the act. We understand the fundamental point that law of succession not applied in a case of agricultural land because of two reasons. One is the parliament have no legislative competence to apply law in a case of agricultural succession. And different state governments have legislative competence. They enacted the revenue codes and they prescribed a specific law of succession in reference to the agricultural land. But friends, when a person converted the use of land from agricultural to commercial, residential and industrial, then agricultural land become the property and bound to be governed by the Hindu law of succession if they are Hindu. Friends, we also discussed that as per section 5, Hindu Succession Act will not apply on certain property. This act have overriding effect as we discussed section 4 of the act. Friends, on that basis, we discuss the different aspects related with Hindu Succession Act. We also discuss the definitions of agnates, cognates, intestate, and we also understand the application of the Hindu Succession Act in the last class. Friends, in today's class, I will focus on Coparcenary, Coparceners and joint Hindu family. These three are fundamental for the purpose of starting study of succession in reference to Hindu. Friends, so long as we are not able to know about the concept of joint Hindu family, we can't understand the Coparcenary. If you not understand the Coparcenary, you cannot understand the Coparceners and rights of Coparcener. Therefore, these three are related: joint Hindu family, Coparcenary and Coparcener. And these are very fundamental because we cannot understand the application of section 6 of Hindu Succession Act without studying this. Therefore, friends, in this lecture, I will discuss you about the joint Hindu family, about the Coparcenary and about the Coparceners, Coparceners' rights, liability, disabilities, and we also discuss about the property. Friends, the application of law is totally dependent on the basis of the property. What is the nature of property? Whether property is paternal property or the property is self-acquired property. Because in paternal property, a child may claim partition because of Coparcenary. But in self-acquired property, so long as the father exists, father will be considered as absolute owner. No one can claim partition during the lifetime of the father. So therefore, friends, it is very interesting to study what constitutes Coparcenary property and what not. Because without understanding of this point, we cannot start our discussion and understanding about the succession, friends. Friends, therefore, first I want to discuss with you the learning objectives of the today's lecture. Friends, The students will able to understand the meaning of a joint Hindu family, meaning and the concept of the Coparcenary and Coparcener, doctrine of sole surviving Coparcener, difference between the Coparcenary and joint Hindu family, and doctrine of survivalship and devolution of interest in a Coparcenary property. These are very fundamental, and on that basis we are able to understand. These are certain objectives, and we will able to understand these with the discussion, friends. Friends, now the first concept, that is the joint Hindu family, friends. Friends, the joint Hindu family is an institution of Hindu jurisprudence. Friends, family is the basis of Bharat, and joint Hindu family is the core basis of Bharatiya culture and tradition, friends. Therefore, in number of cases, court concluded that we will presume that family is joint family unless contrary is proved. Friends, the origin of joint Hindu family you may trace in the ancient text of Smritis, Dharma Shastra. Friends, it is based on the presumption that father has absolute authority. However, with the passing of time, the system was diluted and conferred equal right to son by birth. Friends, how we can explain the story of formation of joint Hindu family? In a case of Sunil Kumar versus Ram Prakash, the Supreme Court observed that a joint Hindu family includes all the male descendant up to any generation in a male line from a common male ancestor, their daughters, their wives, widows, mothers, and their unmarried daughters. Friends, now the point is joint Hindu family. Friends, a daughter ceases to be a member of her father's joint family on her marriage and become a member of her husband's family. Law is very simple and clear, friends. After the marriage, daughter lose the membership of father's joint Hindu family and acquired the membership of husband's joint Hindu family. The divorced wife ceased to be the member of her husband's joint Hindu family, but judicially separated wife or wife who is entitled for separate residence with maintenance considered as a member of joint Hindu family. Widow after the remarriage ceased to be member of her deceased husband's joint family. It does not necessarily require more than one male member to constitute a joint Hindu family. Under Hindu law, a joint family may consist of a single male member and the widows. Friends, the point is also simple and clear. Joint Hindu family need not more than one male member should be there. A male member with widow and wife may constitute joint Hindu family. In a case of Surjit Lal versus CIT, the court observed that widow and unmarried daughter can create a joint family in exceptional circumstances. So this is the basic law about the joint Hindu family, friends. Friends, now I want to discuss certain other aspects of the joint Hindu family. The member need not be associated with the possession of joint family property, and no equal right in the context of the property, and the existence of joint property is not an essential condition for the joint Hindu family. Generally, scholars treated that for the purpose of joint Hindu family, there must be joint property. But it not mean that in the absence of joint family property, a family cannot exist. In this point, we are able to draw the differences between Coparcenary and joint Hindu family. Coparcenary cannot exist without property, but joint Hindu family may exist without property, friends. Friends, now I want to focus on the membership of the joint Hindu family, and membership of joint Hindu family may acquired by three way, by birth, and we also focus on section 16 of Hindu Marriage Act, where child of wide and wideable marriage confer the legitimacy, friends. By birth, a person may be the member of joint Hindu family, by adoption and by marriage also. Friends, traditionally under the Shastric Hindu law, joint family have a relationship with Sapinda relationship. A joint family is a natural association. It is based on Sapinda relationship. Those who are not Sapinda cannot be the part of joint Hindu family. Sapinda comes into the existence only in three ways: by birth, by adoption and by marriage, and do not in any other way. Two persons, if Sapinda, then they be treated as the member of joint Hindu family. If you are not Sapinda, it is very difficult to say that you are the member of joint Hindu family. Obviously, you can't be treated as the member of joint Hindu family. Friends, now I want to focus on certain case, Bhagwan Dayal versus Revati Devi. The court examined the effect of a separation of one member of joint Hindu family on the joint family status and on the remaining members in the light of Privy Council decision in Palani animals case. The relevant observation is as under. The general principle is that every Hindu family is presumed to be joint unless contrary is proved, but this presumption can be reverted by direct evidence or by course of conduct. It is also settled that there is no presumption that when a member separates from others, that the latter remained united. Whether the latter remain united or it must be decided on the fact of each case. Privy Council also held that presumption in the favor of joint Hindu family unless the fact prove contrary, and contrary may be proved by either by evidence or by the conduct of the parties, friends. Now the fundamental question is, friends, what is the basis of jointness of joint Hindu family? A Hindu joint family is joint not only because of estate but also because of food and ownership. But some scholars concluded that estate is essential of the jointness. Jugal Kishore versus Narayan Chand, the Calcutta High Court concluded that the family does not become divided unless there is a division in property, even if kitchen and worship are separated. So long as the property is not divided, no one can say that the family is divided. Friends, now I want to focus about the Karta. Karta is considered the manager of joint Hindu family. Generally, the rule is that senior most Coparcener of joint Hindu family is appointed as the Karta of family. But if all Coparcener agree, then the junior male member may become Karta. In a case of Tribholi Vandas Hari Bhai Tamboli versus Gujarat Revenue Tribunal, the Supreme Court observed that the management of joint Hindu family property goes to a person by birth and is regulated by the rule of seniority. In CIT versus Seth Govind Sugar Mill, the Supreme Court also observed that as a widow is not entitled to become a Coparcener, she cannot become a Karta. Friends, this is all about the joint Hindu family. Friends, the idea of joint Hindu family is crucial because joint Hindu family is a social institution which exists. On the basis of the joint Hindu family, we are able to understand the Coparcenary and Coparcener. But friends, the membership of joint Hindu family may be acquired either by birth, either by adoption or by marriage, not by other way. And The composition of joint Hindu family includes the lineal male ascendants, their wives, widows, unmarried daughter constitutes a joint Hindu family. And Karta is the manager of joint Hindu family. Generally, Karta is senior most male member of the family. But by the consultation and agreement, junior may also work as a Karta. Karta have a different kind of rights under Hindu law. Karta may sell the property, but right of Karta is not absolute. Dharma marge kutumbarthe. Karta can sell the property, not in all circumstances. Karta is just a manager, just a trustee to protect and enhance the property, manage the property. This is the role of Karta. Friends, now after the discussion of the joint Hindu family, I want to focus on the Coparcenary. Friends, what is Coparcenary? Coparcenary is an institution which exists within the joint Hindu family. And the composition of the Coparcenary is senior most male member and next 3 generation constitutes a Coparcenary. Coparcenary is institutions which manage the property. A Hindu Coparcenary is much narrower body than the joint Hindu family. It includes only those persons who acquire by birth or adoption an interest in the joint or Coparcenary property. In Sunil Kumar versus Prem Prakash, the court observed that all those members of the joint Hindu family have interest in the property are the member of Coparcenary. Under the classical Mitakshara law, a Coparcenary consists of the last holder of the property and his 3 generations of unbroken male descendants who acquire a right in the ancestral property by birth. Friends, now we can understand the story of the Coparcenary, friends. Last holder of the property and next 3 generations. This is the rule, friends. And we can understand the story on this basis of the chart. Suppose A is the last holder of the property and next 3 generation constitutes Coparcenary. Last holder and next 3 generation. After the death of A, Coparcenary exists, last holder B and next 3 generation, this becomes the Coparcenary. And after the death of C, the Coparcenary may exist among them. This is the point, friends, which should be considered, the last holder and next 3 generation of the party. But friends, please must understand the point. The point is, so long as A is alive, Coparcenary exists between next 3 generations. After the death of B, the Coparcenary cannot extend to D. Why? Because last holder next 3 generations. After the death of B, the next become entitled to the part of Coparcenary. So this is the rule of Coparcenary. Last holder of the property and next 3 generation. Therefore, if a person dies within the purview of Coparcenary, it cannot change the composition of Coparcenary, as I explained in the example, friends. Friends, second illustration is about the different kind of family. A is the last holder of the property. A Coparcenary exists, last holder and next 3 generation. 1 generation, 2 generation and 3 generation. Therefore, Coparcenary will exist among all. All will be treated as a member of Coparcenary. And after the death of A, Coparcenary may exist between them, friends. The point is very simple and clear that suppose, friends, if death happened so long as A is alive, coparcenary exists between them. After the death of B, no change. After the death of C, no change. After the death of D, no change. Change only be happened after the death of A. Then coparcenary will extend to the next generation. This is the point which should be focused when we discuss about the idea, friends. Now friends, I want to focus on the rule regarding to the coparcenary. Membership of the coparcenary will be acquired by blood or through the valid adoption. No person can be married and no person can be married or by married, or no stranger can by the agreement become a member of coparcenary. Friends, a person may be considered as a member of coparcenary only and only when either by birth, either by adoption. Marriage and agreement cannot provide you a status of coparcener. Under the classical Hindu law, no female could be a member of coparcenary. In Mitakshara, after 1005 amendment, the daughter is also included in coparcenary. The senior most male member is called the last holder of the property, and from him a continuous chain of 3 generations of male members forms the coparcenary. These males up to 3 generations from the last holders of the property have a right by birth in the joint Hindu family property and have a right to ask partition of them. Coparceners have a rights and coparceners also have a rights to ask partition to them. Friends, a coparcenary cannot exist with only one coparcener. At least 2 coparceners are required to constitute coparcenary. A coparcenary is purely a creation of law. It cannot be created by the act of parties. However, only the adoption a stranger may be introduced in coparcenary. Illegitimate sons are not in coparcenary. Wife has the right to maintenance against the property of the deceased coparcener, but wife cannot be treated as a coparcener. In CIT versus State Gobind Mills Limited case, a widow of a deceased coparcener is not a coparcener as held by Supreme Court. Friends, now I want to focus on the idea of sole surviving coparcener. When all the coparcener dies, leaving behind only one male member, then surviving coparcener is called the sole surviving coparcener. As a general rule, a minimum of 2 male members are required to form a coparcenary. The sole surviving coparcener has extensive right over the joint family property as an absolute owner of the property. If a son, whether after the adoption or by birth, comes into the existence after the alienation of coparcenary property, he cannot challenge the alienation. However, if the son adopted or born exists before the alienation, he may challenge it. Sole surviving coparcener is very simple idea. The idea is when only one coparcener exists, then coparcenary will considered as sole surviving coparcener. And sole surviving coparcener may exist unless other male member either by adoption or by birth included in coparcenary. Sole surviving coparcener have absolute right over the property, but when birth taken place in a family, then son, now daughter also become the member of coparcenary and they may restrict to the sole surviving coparcener. Friends, now extension are the end of sole surviving coparcener. Friends, section 6 subclass 3 of Hindu Succession Amendment Act 2005 has abolished the rule of devolution by survivalship. The result is that on the death of one of the last two Coparceners, the surviving Coparcener gets only his own interest in the Coparcenary property. The property allotted to him on the fictional partition is a separate property. So long as the Coparcenary exists, property is joint. After the partition, property becomes separate, friends. Friends, now I want to focus on the doctrine of survivalship. Doctrine of survivalship is also a unique idea which exists under the domain of Hindu law. Survivalship simply means that who survives will take the share. In Coparcenary, every Coparcener exists. After the death of a Coparcener, share of the deceased Coparcener will be taken by the living Coparcener. This is the rule of survivalship. The share of the Coparceners are not specified and interest to and subject to change with birth and death of Coparcener in the family. Under the classical law, on the death of a Coparcener in a joint family, his interest in the property is immediately taken by those Coparcener who survives him. He leaves nothing behind out of his interest in Coparcenary for his female dependent. His interest merge with the interest of surviving members of Coparcenary. A surviving Coparcener gets the interest of the deceased Coparcener not as a representative of the heir of the deceased, but because of the continuation of the community or unity of the ownership of the property. Friends, as I already told you that means after the death of one Coparcener, living Coparcener will get the share of deceased, not as a representative but because of the jointness and community of ownership of the property. But doctrine of survivalship now fundamentally abolished by the enactment 2005. Now the property is devolved as per the rule of inheritance, not as per the rule of survivalship. Friends, as I discussed with you that after 2005 Amendment Act under section 6, if deceased Coparcener has disposed of his Coparcenary interest by his will, the doctrine of survivalship was diluted to the great extent in following cases. After the 2005 Amendment Act, section 6, if deceased Coparcener has disposed his Coparcenary interest by his will, if the Coparcenary interest of Coparcener has been attached for the execution of a decree of during the lifetime of a Coparcener, if the interest of deceased Coparcener is vested on his insolvency in the official assessee or the official revenues. Why Coparcenary is limited? The last holder of the property and next 3 generations, according to Hindu text, only descendant up to 3 generations can offer spiritual rights to the ancestor, Pindadan, etc. Therefore, such thing exists. So friends, I discussed the idea of Coparcenary is an institution which exists within joint Hindu family for the purpose of regulation of property. Composition of Coparcenary includes last holder of the property and next 3 generations. The property will be devolved by the doctrine of survivalship, and doctrine of survivalship means who survives will take the property. Now doctrine of survivalship is diluted, and the question is why doctrine of Coparcenary is limited? Because of the spiritual ability of a descendant to offer Pindadan and etc. to the ancestor. Friends, now I want to focus on a fundamental question, item of a joint Hindu family property. Friends, if the property is joint property, then the owner cannot devolve the property unless the property is divided. or partition taken place. Therefore, knowing the nature or examining the nature of the property is very crucial for the application of Hindu Succession Act. Joint property cannot be transferred without partition, and separate property may be transferred without any partition. Joint property will devolve under section 6 and separate property will devolve as per the intestate and testamentary succession. Therefore, knowing the nature of property is very crucial, friends. The property is categorized in two different categories: paternal property, coparcenary property, joint Hindu family property. These are same. These connote same meaning: paternal property, joint Hindu family property, and coparcenary property. On other hand, separate property, personal property, self-acquired property are different. Now I want to explain two different kind of property with you, friends. The first is paternal property. The property that a man inherited from his father, grandfather, great-grandfather is known as paternal property. In a case of Deepo versus Basan Singh, the court held that the paternal property of a person remains his personal or separate property until a son is born to him. The moment the son is born alive, the property becomes joint between them. There is no coparcenary between father and his son as regard to the self-acquired property of the father, because son have no ownership with the father and cannot claim partition. The word paternal would automatically make irrelevant the property inherited from maternal ancestry after the 2005 Amendment Act. In context of daughter, it is ancestral towards daughter, son's daughter and son's daughter. The paternal property means a property which is inherited by a person by the parents. Then the property will treated as paternal property. Paternal property, your son will acquire the share at the date of birth, may claim the partition when he want. This is the paternal property. Second example of the joint Hindu family property is acquisition of property with the help of joint Hindu family property. The property that is acquired by the investment of or the expenses of joint family property gets the character of joint family property. The income of joint Hindu family property or property received in the exchange of joint Hindu family property also considered as joint Hindu family property. So when a person developing the property with the help of joint Hindu property or because of exchange you have a property, then your property is known as joint Hindu family property. The court laid down the test in Rajkumar Singh case. The different kind of tests laid down how we can understand the property. Whether the income received by a co-partner of a joint Hindu family as a remuneration had any real connection with the investment of joint Hindu family fund. The property which is created by any family member have a real connection with the investment of joint Hindu family fund or not. Whether the income received was directly related to any utilization of joint family assets, whether the family has suffered any detriment in the process of realization of income, whether the income was received with the aid and assistance of joint Hindu family fund. Now, item of a joint Hindu family. The third is joint acquisition without the help of joint family property. If a person acquiring the property with the help of joint Hindu family property, obviously the property also known as joint Hindu family property. But in certain cases, if you are earning the property, creating the property without aid of the joint Hindu family property, also be considered as the joint Hindu family property. If the property is earned by a joint labor of some or all the coparceners without the help of joint Hindu family property, and intention of the property holder is also important. Why they created or generated the property? The property voluntarily provided by any coparcener to the coparcenary is also known as joint Hindu family property. In this regard, evidence is important, and this is the question of fact whether this property is a joint property or not. So fact and intention evidence, and then you can declare. Recovery of joint property. If lost property is recovered with the help of joint family property, it is assimilated into the joint Hindu property and will be considered as joint Hindu family property. Gift or bequest. The character of this property in the hand of the holder is to be determined not merely by the relationship between donor and donee, but on the basis of intention of donor. Share allotted on the partition have a dual character. It may be separate property, but when a son take birth, then this property again become joint Hindu family property. Government grant, if grant is dedicated to the family, is a joint Hindu family. The property held by sole surviving coparcener, so long as sole surviving coparcener exists, indivisible rights, indivisible property. But after the death, this property may also constitute as a joint Hindu family property. These are the illustrations of the joint Hindu family property. On these properties, a person have no right. You cannot transfer it, and any person in the family may claim if they are entitled to claim partition. Now the second point is separate property. Friends, separate property have a different character. The property in which a coparcener has no claim is known as separate property. Person having exclusive ownership or may own a joint property, but property does not belongs to the coparcenary. The co-owner are not coparcener in respect, friends. Means, friends, partnership properties, joint property because of partner, this is not a separate property. Friends, the character of separate property, first character is full ownership of the owner. Separate property is personal and exclusive property. He has full ownership over it. He can deal with in accordance to his intention, intent and purpose. He can make a will in respect to sell, mortgage, exchange or gift. No coparcener can object it if the property is self-acquired property. And second, devolution by inheritance. Classical Hindu law, if the property is joint Hindu family property, coparcenary property, then rule of survivalship apply. But if the property is self-acquired property or personal property, then rule of inheritance will apply. But now, friends, there is no difference between the rule of survivalship and inheritance, because survivalship now abolished and only property will dissolve as per the rule of inheritance, friends. Now I want to focus on the different items of the separate property. Obstructed heritage, friends. Obstructed heritage means the property which belongs to the father. So long as the father exists, father have a absolute right over the property. That is obstructed heritage. Father is obstruction in a way of inheriting the property from the father. Any kind of property on which father have absolute right is known as obstructed heritage, and obstructed heritage is known as separate property. Friends, property inherited under section 8 of Hindu Succession Act. Yudhishthir versus Ashok Kumar, the property which is inherited from the father under section 8 of Hindu Succession Act 1956 by a son is his separate property. Inheritance from the natural father after adoption. Friends, in the case of adoption, a son may inherit something before the adoption from the father. What he inherited by the natural son before the adoption shall be considered as separate property of the child. Self-earned property generally also considered as self-acquired property, separate property. Now gains of learning. Friends, under the classical Hindu law, if you learn certain knowledge and family spent money on you, then your earning is not your earning. You are bound to contribute in joint Hindu family. This rule was amended in the year 1930 when British Parliament passed an act, Hindu Gains of Learning Act. Now Hindu Gains of Learning Act 1930, a Hindu earn the property because of learning become exclusive property of Hindu, and the person becomes separate owner of the property. And section 3 of the act overrides the custom. If anyone earns the property by education, whether elementary, technical, scientific, or training of every kind, is a separate property of a person. Before the Hindu Gains of Learning Act, the acquisition from the learning that is obtained, which the expenses of the paternal property was not considered separate property of person. But now fruit of learning belongs to learner. What you learn because of training, it's your property. Friends, I concluded my discussion on the two different kind of property, separate property and coparcenary property. And I discussed with you different illustrations and items related with separate property and coparcenary property. Now I want to deal with the status of coparcener. Status of coparcener may be explained on the basis of three different points: rights of coparcener, disability of coparcener, and obligation of coparcener. Right of coparcener. Friends, first is right to maintenance. Every coparcener, whether major or minor, has a right to get maintenance out of his coparcenary property. Ram Rao versus Raja Pittapur. A coparcener has right to maintenance from his joint Hindu family property, and if it is denied, she can sue the Karta for maintenance. Right to joint possession and use fruit. They have right to joint possession and use and enjoyment of coparcenary property. Rights of coparcener also includes right to survivalship, right to make a will of one's interest, right to restrain unauthorized disposal, right to demand partition, a right to surrender own interest. These are the rights of coparcener, friends. Friends, disability of coparceners. Coparceners also disable in certain context, especially in context of alienation. No coparcener can make a gift of coparcenary property unless the property is divided. The coparcener also disabled to make substantial change in the joint property. Suitable change is possible, but substantial change and modification is not allowed under the law, friends. And disability of coparcener also includes management. A karta alone has a right to manage the affairs. No other member can do so unless they get delegated authority from the karta. Friends, these are the disability of coparcener. An obligation: every coparcener is liable to repay the loan that was obtained by the purpose of the family. This obligation exists to the extent of his own interest. Friends, after the discussion of joint Hindu family and coparcenary, we may discuss the difference between the joint Hindu family and coparcenary. Joint Hindu family, a bigger institutions, includes coparcenary within it. Smaller institutions, coparcenary. Joint Hindu family, there can be a joint Hindu family without Coparcenary. A Coparcenary cannot exist without joint Hindu family. Joint Hindu family is not 100% related with property. It may be, not maybe, but property is must for Coparcenary. Both male and female are the member of joint Hindu family. Only males and daughters may be the member of Coparcenary. Membership of joint Hindu family may be acquired either by birth, adoption and marriage, but membership of Coparcenary only by birth or adoption. Joint Hindu family may consist of two male members or one male and one more female members. But friends, two male members are required, only exception is sole surviving Coparcener. Plurality of membership exists in joint Hindu family where father, mother, wife, widow, son, daughters are there, but only males and only daughters are the part of joint Coparcenary. Only males and only daughters are the part of Coparcenary. Friends, on that basis we are able to think about certain cases. Can a Hindu joint family exist without any Coparcenary property? Why was 2005 amendment to section 6 of Hindu Succession Act necessary? If the partition occurs, does the joint Hindu family legally cease to exist? Friends, before concluding today's lecture, I want to summarize what we discussed in class. Friends, we try to understand the idea of the joint Hindu family. Joint Hindu family means institutions which exist within a family, where diversity of memberships are there. Joint Hindu family is a natural institutions of Bharat, and especially Hindus. Joint Hindu family is a bigger institution. Coparcenary exists within joint Hindu family. Coparcenary is an institution which is meant for the purpose of managing the property, which includes last holder of the property and next 3 generations. Member of Coparcenary is known as Coparcener. And friends, after 2005 Amendment Act, daughter is also treated as Coparcener. Friends, division of property is also crucial for the purpose of inheritance. Therefore, property is categorized in 2 broad categories: joint Hindu family property and separate property. Joint Hindu family property will devolve as per section 6 and separate property will devolve as per section 8, 9, 10, 11 and in case of female. Friends, the law is very simple and clear, and therefore what is joint Hindu family property and what is separate property we must understand properly. The very interesting fact about the Hindu Gains of Learning Act 1930. Before this act, what you earn because of your learning considered the property of family, but after this act, fruits of learning belongs to learner. Means you may enjoy the property what you earn due to your hard work. Friends, we also made a comparison between the joint Hindu family and Coparcenary in order to understand the subject. We also discussed the status of the Coparcener by studying the rights of Coparcener, obligation of Coparcener and disability of Coparcener. Rights, they may claim maintenance, they may use enjoyment, survivalship. Obligations, they are bound to pay debt. Disability, they cannot sell the property unless the property is divided. These are some fundamental aspects. On that basis, you are able to understand the joint Hindu family, Coparcenary and Coparcener. Thank you for your patience. Thank you, friends.